All right. Mr. Yoder, please proceed.
Thank you. May it please the court, Michael Yoder for defendant and appellant Samsung Electronics. I am joined at council table by my partner, Anton Metlitsky.
I think we saw you the other day, did we not? Welcome. Nice to see you again.
Thank you. So I hope you take it easier on me than you did on my partner.
Oh, we were gentle.
So with the court's permission, I would like to reserve 5 minutes for rebuttal and to address any questions or issues that come up on the cross appeal that may be argued during the respondent's argument. The district court held at summary judgment that Netlist had properly terminated the parties' joint development and licensing agreement because of Samsung's purportedly material breaches of Section 6.2 and Section 3 of the JDLA. That holding is wrong for the many reasons we've identified in our briefing, and as a result of those errors, the judgment should be reversed. Judgment should be ordered for Samsung, or at a minimum, there should be a trial on the issue of materiality, which is at the heart of the third claim for relief. The holding, though, is especially wrong for 3 reasons that I'd like to address today. Of course, happy to and prepared to answer any questions the court has on the other issues that are raised. But I think there's 3 key issues where the district court got it wrong, and because of that, this judgment needs to be reversed. First, it's erroneous interpretation of Section 6.2 of the JDLA. Second, it's erroneous interpretation of Section 3 of the JDLA. And then third, it's error in taking the fact-intensive issue of materiality away from the jury, deciding the issue as a matter of law on summary judgment in the face of conflicting record evidence.
Let me ask you this.
Sure, Your Honor.
I gather you concede New York law controls here, right?
Yes, there may be some procedural issues,
right,
but yes.
Substantively. So we're talking about a requirements contract here, essentially. And if I understand New York law correctly, and my colleague to my left is an expert in all that, so we're glad she's here to help straighten it out for us. But my understanding is that under New York law, whether there's ambiguity, you can look within the contract, but not outside the contract, kind of like what we have, 1541 here in California.
Yes.
If that's correct, what is your best argument that 6.2 is just misread by the judge, the district judge?
Absolutely, Your Honor, and I agree. New York law is a four corners state where you first determine ambiguity, whether the agreement's reasonably susceptible of more than one interpretation based upon the agreement itself, as opposed to the way California does it, where you have to consider the extrinsic evidence to be able to make that determination. So fully agree with that. But the point is the district court looked at the language of Section 6.2 in isolation.
Well, let me ask you, is it going to be your position that it's ambiguous and that it should be a jury trial on the meaning of it? Or do you say it clearly states your position and it should be read to apply only to the JDP?
Yes, Your Honor. Our position is that it is unambiguous when the contract is read as a whole and when the apparent purpose of the contract is considered and the structure of the contract is considered along with the text.
So is it your position that Samsung never had any supply obligation under the agreement based on the language I think that you cite that says 6.2 imposed a supply obligation if the joint development product ever, quote, became commercialized?
Well, let me just finish answering the first question, though, and that is, but in the alternative, there is no question but that this agreement is reasonably susceptible to both proffered interpretations, whether the scope is limited to the joint development project or unlimited, as Netlist contends.
Then what happens if we determine it's ambiguous? Does it go back for a jury trial?
Well, it's a good question, and as Your Honor probably knows, courts handle that issue quite differently in terms of whether the issue just is presented to the jury as to whether there's a breach and then there's argument, whether the court gives fact questions to the jury to answer as to the disputed evidence.
Does the damages verdict continue to remain, or do they have to redo damages in light of that?
I think it would depend on the nature of the issue that would be remanded. I think that under a certain scenario, the damages wouldn't change, but under a different scenario, it would, depending upon the verdict. I think that would have to be hashed out with the district court.
I'm sorry, you
Right.
probably want to answer.
So, and I apologize. So the point is this: there was an obligation under 6.2. We don't deny that. There was an obligation to supply the memory chips in connection with the joint development project. There was an obligation to supply it during the development stage, so they had access to those chips. And if the project were successful and the NVDIMP product were commercialized, there would be an obligation to supply those memory chips to Netlist in order for Netlist to sell the product.
But on the first point that you make, are you asking us to insert language after the word products that says in connection with the JDP? I mean, that language is nowhere in 6.2. There's no language that ties it to the JDP, and there are other provisions in the contract that stand alone, separate and apart from the JDP. So how would we resolve this, what you claim to be an ambiguity, or maybe you say it's clear in the other direction, without the specific language that I think you need in that section that ties it to the JDP?
Well, there is no language in 6.1 either that says NVDIMP controller in connection with the joint development project. There's other provisions in the contract that clearly relate to the joint development project that don't also say in connection with the joint development project. That's why you have to look at the structure of the agreement in order to interpret specific language. For example, in section 3.1, there's an $8 million NRE fee that's paid. It's clearly for the joint development project, but it doesn't say it's specifically for the joint development project.
Counsel, let arguendo, okay?
Sure.
Let's say that I, after looking at the contract as a whole, that I conclude that section 6.2 is ambiguous. Now, that's contrary to what both parties say, but I do say,
right.
say it, that's arguendo, that's what it is. What do you do with that? If it's ambiguous, how does that affect your case?
Well, if it's ambiguous, then under New York law, you have to look to the extrinsic evidence to determine what the party's intent was. And the party's intent is the controlling issue there. And in this case, the most compelling extrinsic evidence is the MOU, the Memorandum of Understanding of the Parties, which followed the exchange of two term sheets, which made clear that the memory chips were to be raw material as part of the joint development project. And Netlist CEO, Mr. Hong, admitted in his deposition that under those term sheets, the raw materials were for the NVDIMP product.
And you're making the point, you have to go outside the contract. So
Right.
Then you have to go back for a trial then, don't you? Don't you have to go back and everybody puts in all their evidence and says all what you're saying eloquently here, and then a jury or a judge, depending which way you go, decides whether that's correct. Isn't that right?
Probably so, unless the district court would decide that the extrinsic evidence is undisputed.
But that's not true here, correct? There's evidence on both sides of the issue when you look at extrinsic evidence, correct?
Your Honor, I think that there is disputed facts in the extrinsic evidence that was offered. Our position is the MOU is so clear and compelling, and the deposition testimony of Mr. Hong is so clear and compelling, and the record shows not only that the MOU clearly included the supply obligation for the joint development project, period, that in the negotiations and for the language of the JDLA, when any deviation was made from that MOU, Netlist's position was, no. We want to go back to the MOU. That's our agreement. We're not going to deviate from it. We're not going to have any conflict.
But you're, with respect, what you're doing is eloquently arguing what you would say to the trier of fact in a trial as to why you should win.
Right.
I've practiced primarily business law for 37 years. This contract is a mass of confusion if you look at it.
Right.
Somebody has to straighten it out, right?
Right.
Okay. So are we really saying, if that's right,
Right.
that this needs to go back and somebody has to straighten it out?
At a minimum, certainly it should, Your Honor. Again, we think the extrinsic evidence is compelling, but I can understand a different point of view, that there are facts here that should have gone to the jury and it should have been sorted out on the whole. And that's certainly true as to the materiality issue. Because recognize that a lot of the evidence relevant to the interpretation of 6.2 is equally relevant to the issue of materiality, as to whether, if there was a breach, whether it was material and justified termination. All of that evidence was before the court on summary judgment. And he glossed over it and basically said, nope, even though materiality is an issue of fact, typically, I think here, I'm just going to decide it as a matter of law. And that was there.
And that's another reason, because it is at the summary judgment stage that maybe it needs to go back for a trial.
Absolutely, Your Honor. Absolutely.
I got to say, the difference in the way summary judgment is treated today and when I started practicing is really different.
I can relate to that.
At that point, it almost never succeeded. Now it happens a lot. But
right.
Maybe this is one of those cases where it doesn't succeed. Who knows?
Yeah, well, absolutely not. And it's a little confusing. You go back and you look at the record in terms of what was really being brought before Judge Scarzi. But the fact is that, and I think this is really key on the issue of materiality, that first of all, on Section 3, there's no question that there were fact issues as to materiality. There's no question about that. But Judge Scarzi said, no, disregarding the conflict about whether this is material because you didn't pay when it was due, and therefore there was an immediate breach at that point in time.
Do you think that's ambiguous? And do you think that would go back for a trial?
Absolutely, Your Honor. Well, again, we don't think the provision's ambiguous. We don't think it's reasonably susceptible of this strict liability interpretation. Because the way Section 3 is set out, even just Section 3, that if there's a withholding of tax, the remedy isn't to declare breach and seek termination. And Netlist didn't do that. This withholding was in 2015. They didn't declare a breach until 2020. 5 years, because the remedy under that section is to seek a refund, and Samsung then reasonably cooperates in seeking a refund. So the way the district court interpreted this, Samsung would have an obligation to reasonably cooperate in proving its own breach, which then would cause a termination of the contract. That's nonsense.
It seems like the language of 3.1 suggests cooperation, and depending what came out of it, then it would go from there. There was no strict liability.
Absolutely.
Is that right?
Yeah. And so, but that also goes to materiality. One, it goes to whether there's a breach. It also goes to whether it's material. Did Netlist really believe it was material when they sat on it for 5 years and didn't declare a breach? And when finally the higher Korean tax authority overruled the lower Korean tax authority, was there a breach when the lower Korean tax authority agreed with Samsung? It's nonsense, can't be. But when the higher authority decides there's a refund with interest, there's nothing to cure. But yet under the district court's interpretation, Samsung's out of luck. Never could have cured, never given a chance to cure, but there's this strict liability based upon what is determined 5 years later. So not a breach, but also that should have gone to the jury on materiality.
Well, I gather from Samsung's perspective, if there's ambiguity, and if Section 6.2 is interpreted the way you think it should, considering the totality of the circumstances, the tax gets reversed as well because there's no ambiguity there, it's not strict liability, and the declaratory relief gets overturned because the others didn't happen. Is that correct?
Right, that's our position, Your Honor.
Okay.
But even if the court doesn't agree that that should be the outcome, there needs to be a remand and a trial on these issues, for sure. And that's true as to materiality on 6.2 as well. And where I was going with that, when you go through the briefing on the issue of materiality, Netlist's argument was really, it was material because the supply obligation was a primary consideration for giving these licenses. Well, number one, if you look at the JDLA and you look at the recitals, The recitals are very clear. And, parties put recitals in agreements to make sure language isn't tortured down the road by lawyers and courts, right? Here's what our purpose is. Interpret this agreement consistent with our purpose. And when you look at the recitals, what does it say about the licenses? Whereas in connection with their collaboration hereunder, the parties wish to grant to each other a cross-license under each party's patents. The licenses are being given in connection with the collaboration. That's the joint development project. And Netlist got a whole bunch of consideration in addition to this supply obligation. If there were an unlimited supply obligation, it would be called out in some fashion.
Do you want to say, I thought you said you want to say 5
Yeah,
minutes. It's up to you entirely, of course.
No, and I'm watching the clock, Your Honor, because I got a sense that we need to do that. But the thing I would say, though, just on materiality, is that when you look at the record before Judge Scarzi on the 6.2 issue in materiality, Netlist's argument was that the supply obligation was the primary benefit that it received. And Judge Scarzi agreed with that. He said this was integral. This was a key component. And he made a factual finding based upon essentially a post hoc declaration by Netlist CEO. And he disregarded all the other evidence in the record as to whether this was the primary benefit.
So it wasn't an undisputed fact?
Pardon?
It wasn't an undisputed fact then? In
It
other
wa-
words,
it
the
was
fact-
dis- it was disputed,
the fact
very
was
much disputed. Yeah,
He
whether
shouldn't have resolved it against you because it was disputed.
Yeah, absolutely not. I mean, even just on his, and he erred as a matter of law too, because instead of applying the multi-factor test of materiality, he just picked out this one issue. And even on that issue, there was a conflict in the facts in the record.
Can I just ask you one further question? You said that you did supply these memory components in connection with the JDP, what was being developed?
Yes, Your
Why
Honor.
was there a need to do that?
To create the product.
So that
But
there
to
was
try to-
some, did you also during that time, is the record clear that you submitted memory components for Netlist other uses?
Yes, there was. But that was true before, during, and after. And it was done subject to purchase orders and acknowledgments that didn't reference the JDLA. So the party's practice continued the same way during the JDLA as before. And our position is that doesn't really prove anything. You really have to get into the extrinsic evidence to decide why are they doing that. Is it because of this unlimited supply obligation, or is it because that's the way the parties had been doing this for years and years? So with that, let me reserve the rest. Thank you very much.
Very well. All right, Mr. Ashley.
Almost good afternoon, Your Honors.
Pretty close.
May it please the court. Matt Ashley for Netlist. This case begins and ends with the plain language of the JDLA and New York's settled contract interpretation principles. You're correct. You don't look outside of this contract to determine whether there is ambiguity. And I want to focus first on the key contractual provision in the case, which is Section 6.2. Section 6.2 reads, and I'll quote it to you, Samsung will supply NAND and DRAM products to Netlist on Netlist's request at a competitive price. That is succinct, clear, and unambiguous language.
But it is, if you will, interpreted by the rest of the contract, including, for example, the recital that Mr. Yoder just gave. And when you look at that in its totality, sounds pretty ambiguous to me. Why am I wrong?
You're wrong in part because he read you the wrong recital.
Let's hear the right
He
one.
didn't read the first recital of the contract, which says, whereas Samsung develops and manufactures, among other things, memory components and memory modules, and Netlist develops and manufactures memory components and memory modules. So it's speaking to the products that these companies produce. And that ties into the supply obligation later that for Netlist is expressly limited in Section 6.1 to NVDIMM-P controllers, and that for Samsung is not limited to either NVDIMM-P controllers or their current position, the Joint Development Project.
Your friend on the other side said that there was a relationship with respect to the sale of the NAND and DRAM products before this agreement. It's my understanding that there was no agreement, there was no contract that obligated Samsung to sell these parts to Netlist, and in fact, it was pretty ad hoc, and requests would be made and not fulfilled or backlogged. And in fact, part of this agreement was to ensure that when those parts were ordered, they would in fact be supplied at the competitive prices that Samsung was selling them for. Is that correct?
That's absolutely correct. And then one of your questions to counsel was, you referenced, Your Honor, the term JDP. That's a point I wanted to make. They stress both in their moving and their reply brief, sort of the linchpin of their argument about creating an ambiguity is to say, well, Section 6.2 is part of Section 6, which is supply of components. And that's why I was tying you to that first whereas clause. They say you should interpret components to be components for the JDP. Well, it doesn't say supply of components for the JDP.
But isn't the controller in the first part a JDP controller? I mean, that is used just for this particular
in this
development.
particular,
Is that correct?
In Section 6.1.
In Section 6.1.
Yes.
That controller is limited to this project, correct? It's not something else.
It's limited to NVDIMP, which is supposed to be the jointly developed product
That's
eventually.
the jointly developed product.
Correct.
So under a heading of supply of components, the first is clearly for the JDP project. Why wouldn't you reasonably read the second clause as also relying or involving that development project?
For two reasons. It's not there, and they could have put it there. Second, even the reference to the NVDIMP is not to the joint development project. It's to that product that's supposed to come out of it. So you have to.
I thought you just told me Section 6.1 was specifically directed to the project.
It's directed to NVDIMP, which is the product that's supposed to come out of the project. There are defined terms in this agreement for the project, which is the joint development project, or JDP. There's the developed product, which is the NVDIMP product. And those defined terms are used throughout this agreement when the provisions intend to limit themselves to, for instance, NVDIMP or the joint development project. And I'll give you an example. Your Honor asked whether or not Samsung's position was whether or not they ever had a supply obligation. Did it ever arise? Because they're now saying it's only for the joint development project. Their actual separate statement of undisputed fact, this is at 2 excerpt of record 154, Samsung's position below was Samsung's supply obligations would only arise if and to the extent the NVDIMP product was commercialized. But this never occurred. That was their position below. Prior to that, their position below was that this was just a pricing obligation, not a supply obligation at all. But that's the mischief that's created when you try to look at other provisions that have a limiting factor and read that limiting factor into other provisions. So the fact that Section 6.1 references NVDIMP and Section 6.2 doesn't is exactly why you shouldn't read either that limitation or an even simpler one for the joint development project into Section 6.2.
Isn't it at best ambiguous?
No, I don't think it's ambiguous at all. They're trying to create ambiguity by saying there are limiting factors in other provisions of this agreement that you should therefore assume you read into Section 6.2. For instance, in the FireGuard case decided by this circuit, the court said the fact that there are limiting provisions in other sections of the contract and they're not extant in the section being interpreted means you don't read them into it. And that's particularly true in the New York Court of Appeal as well, especially amongst sophisticated parties. And these are two sophisticated parties. In the three cases that we cited, the key cases that we cited, it was Vermont Teddy Bear, Rice, and Quadrant, all issued by the Court of Appeal, all deciding as a matter of law that a provision that did not have a limiting factor that was negotiated between two sophisticated parties, you should be exceptionally reluctant, was the language that the Court of Appeal used, to imply a limiting term that was not there and that could have been put there. And
Do you believe that there's any limiting factor under 6.2 as to what they would have to supply? Could you name 5 or 6 other different chips Would they have had to supply those?
No. In fact, there's lots of limiting factors inherent in 6.2. You just named one of them, which is the certain types of products. So there's NAND and DRAM. That's the only two products. Not all memory products, not controllers, for instance. There's also
And you believe that those are adequately referred to in 6.2?
Yes, and there's no, they're expressly spelled out, and Samsung's never contended otherwise. And in addition, there's the limiting factor of the fact that Netlist has to pay the same price that Samsung's other customers are paying for similar quantities. Let's compare that to 6.1. Samsung complains that the way we're interpreting the agreement would create an asymmetry, for instance, in 6.1 and 6.2. There's already an asymmetry. In 6.2, Netlist gets Samsung product at the price Samsung charges other customers. In 6.1, Netlist has to supply its NVDIMM controller to Samsung at a price below the price it charges its customers. So below the price that its normal customers pay. So I don't think there's any ambiguity at all in section 6.2. It was correctly decided as a matter of law, and the attempt to create an intrinsic conflict actually should backfire on Samsung, because under New York law and this circuit's precedent, the fact that provisions and defined terms like JDP, joint development product, NVDIMM, are used throughout this contract, but not in section 6.2, makes it crystal clear you don't read it into section 6.2.
Can I change, if you will, portions of the agreement I want to refer to? If we read section 3.1 to create strict liability, why does 3.2 discuss obtaining refunds?
Well, they only read you one of the words from section 3.2. It's not just refunds. So section 3.2 reads, Samsung shall reasonably cooperate with Netlist in any lawful efforts to claim a credit or a refund or an exemption with respect to any such withholding taxes. So the way this agreement was set up was Samsung was required to pay $8 million in 7 days after invoicing. Samsung could withhold if it was required. And then if Netlist had some right to a set-off, which doesn't have to be because of a wrongful withholding, there's all sorts of reasons why money can be properly withheld, but then you might have a reason based on your own particular circumstances to get a set-off or to get a refund or to get an exemption. It's not saying, and if Samsung improperly withholds, they will cooperate. That is one.
Do you agree that, and I think it was the Korean Supreme Court, if I recall correctly, ultimately concluded that this was not necessary? So it was not a clear statement. You had to go all the way up to get this resolved. They refunded the money with interest. Couldn't Samsung have had a good faith intention in withholding a part of the money based on its understanding of the tax law?
Yes, they could have. And
under those circumstances, why would the whole contract go down based on some strict liability?
Well, it's a function of the fact that payment is material as a matter of law in California, in New York in almost all circumstances.
But the agreement seems to contemplate that you've got a little flexibility here. We're going to work with you. We're going to provide you what you need. We'll cooperate, see how it works out. And in this case, that's what happened. But the Supreme Court said, no, you don't have to do that. But I gather before that was not clear. I'm sure your firm does lots of tax work. In fact, I know it does. And we have an occasional ambiguity and lack of understanding of what our tax law means. No different in Korea, is it?
I assume it's going to be the same almost
So
anywhere.
If that's the case, why is there strict liability here?
Well, it's not strict liability. It's just
in the sense that everything else, you treat it as a material breach, right?
Yes, and Samsung had...
And if they got the Supreme Court of Korea to refund the money, or the parties did, with interest, why is that a breach?
Well, Netlist ultimately did that. The breach is determined, and you're talking, it is a breach. I don't think there's a dispute that there's a breach. They're claiming it's not material. Materiality is determined at the time of breach. And let's remember that what happened here was Samsung went out of its way to characterize this fee as a royalty. Now, you heard earlier in the argument from counsel that it's unequivocally not a royalty, that it related to joint development work, but they took that position, and then Netlist had to go run it down for 5 years. So the breach is determined at the time or the materiality is determined at the time of breach. But I understand what Your Honor is saying, and I don't think we need to focus too much on that today, because materiality is shown enough by Section 6.2, and I really do want to get to something that counsel said about materiality.
But as you consider that, will you respond to what I asked Mr. Yoder? If we arguendo say 6.2 is ambiguous, do we not have to send this back to the district court for a trial?
No, you do not. And that's if you look at the quadrant case, this rule in New York about importing terms, limiting factors, when you have a contract between two sophisticated parties is exalted to such importance. And I'm going to quote you from quadrant. Quote, even when there is ambiguity, if parties to a contract omit terms, particularly terms that are readily found in other similar contracts, the inescapable conclusion is that the parties intended the omission. That's what they told the Delaware Supreme Court on a certified question. So I think even if you think there might be some intrinsic ambiguity, I think the fact that these two sophisticated parties could easily have written into this contract in Section 6.2 supply for NAND and DRAM for the joint development project. They used those defined terms throughout this contract, and they didn't. So
if arguendo, if we find that your client was likewise inconsistent in the way it tried to apply the contract, would that vitiate your argument?
You never get to it, because you only go to extrinsic evidence when you find an ambiguity. And I don't think you should ever get to that. That's not what Quadrant did. You don't look to...
Quadrant found ambiguity, but didn't go to extrinsic evidence?
It isn't clear whether Quadrant did. I think what Quadrant was doing was telling the Delaware Chancery Court how the New York courts would look to this issue. And so it never really said whether or not it was finding it ambiguous or not. It was just noting the importance of this rule in New York that even when something's deemed ambiguous, you don't import terms. So it did not end up going through, probably because it was a certified question. It did not go through the record and look for extrinsic evidence. I want to turn to materiality for a moment, because Samsung never argued, put in facts, or pointed the district court below to any evidence of a material fact dispute on the issue of materiality of Section 6.2, of a breach of Section 6.2. Its sole argument, its sole assertion, its sole claim as to materiality with respect to Section 6.2 was that Netlist's interpretation was wrong.
But that goes to the heart of the agreement, doesn't it?
It does, and that's what Samsung told the district court at oral.
It could be more material than the heart of the agreement.
Yes, exactly. But they're arguing something different now. What they just argued to you was that there is a fact issue, and a disputed fact issue as to materiality, even if you find that Netlist's interpretation is...
With respect, counsel, what I'm understanding Mr. Yoder to have said is, and so my interpretation, if this were a trial court, this is what I'd be saying, and to get my interpretation bought, basically, by the prior effect. I didn't understand him to say this is not a material breach.
No, what I'm telling you is this circuit's precedent is clear that if you claim that there is a disputed fact issue on summary judgment, it is your obligation to argue that there's a disputed fact issue and to point the court to the disputed facts. Samsung did not do that because they never claimed that if Netlist's interpretation were adopted, that there is a disputed fact issue. They said just the opposite. So all the facts they're pointing to now...
You're saying that they said 6.2 is wrong, but it's not material, so don't worry about it. Is that what you're saying?
No, I'm saying they never... Netlist brought a motion for summary judgment on the third claim for declaratory relief, saying that if you accept our contract interpretation, the breach of it was material, and we put in undisputed facts. Samsung did not dispute those facts, and they never put in a counter-narrative or evidence that they actually had disputed facts as to materiality of a breach of Section 6.2. They never did it. The sum total of their entire presentation below on materiality as to 6.2 was you have to accept our interpretation, or that's the only correct interpretation. And I want to cite you to your USA Petroleum versus Atlantic Richfield case, which says you can't do that. You have to raise your disputed fact issue. You said that in Momox versus Donahue. And you cited that, and the federal rules of civil procedure, rules 56C and E, say that exact rule. You can't not raise an issue below. You can't claim or not claim there's a fact issue at all as to materiality as to 6.2, and then claim that the district court erred by not finding a fact issue as to breach of section 6.2.
Again, correct me if I'm wrong. You're saying X, they're saying Y as to 6.2. Somebody's wrong.
Yeah, but that's
a material dispute, right?
We only get to materiality, right, if we're correct. In other words, if our contract interpretation is not correct, then you're not asking me about the materiality of the breach.
Forgive me. Somebody has to decide who's right and who's wrong. In this case, the district judge determined that you were correct. It didn't mean there wasn't a material dispute.
No, the district court, there was two steps. The first step was who is correct on contract interpretation.
Right.
Okay? The district court determined that as a matter of law.
Material issue, right?
That was an issue. And then another.
Material issue.
What's that?
That was a material issue.
That was the key interpretive issue in the case, was who's right on section 6.2. Now, the second part, and you see this in their appeal brief, now they're saying even if you accept it's completely unambiguous and section 6.2 is a mandatory supply obligation and Netlist is correct, what they just argued is there's a fact issue, and the district court erred in not finding a fact issue. The district court erred in not applying a 5-factor test. What I am telling you is Samsung never made that argument below. They never claimed that if our interpretation were correct, that there's a fact issue as to any of these 5 factors. The sum total of their presentation on materiality as to section 6.2 was a single sentence in their MSJ brief saying our interpretation is correct. That's why the district court said there's no serious dispute as to materiality of section 6.2. So if you...
Assuming your interpretation of this provision is correct.
Correct. If you find that section 6.2 is an unambiguous supply obligation,
then it's by definition material.
It's by definition material, and everything that the district court did should be affirmed. And I want to impress upon you that I don't believe that Samsung, they're raising these arguments and they're going to mention the trial that happened afterwards. All that occurred, it was the tip of the tail of the dog in this case, cost of cover damage. It all occurred after the summary judgment ruling. And when they came back, they in fact came back 10 days after the judge issued the summary judgment ruling. And they filed a motion for reconsideration. They brought in new counsel, and they raised this 5-factor test, and they claimed that you didn't find a fact issue. And the judge said, no, you never raised a fact issue. You never claimed there was a fact issue as to materiality. So if you affirm as to our interpretation of section 6.2, and I do believe it's unambiguous, then materiality follows as a matter of law. The judge could not have erred in not finding a fact issue that Samsung never argued existed.
But if we conclude that it was ambiguous, then what happens?
Well, like I said, the first thing I think you go to is to the New York Court of Appeal Authority that I referenced, Quadrant, Rice, and Vermont Teddy, and I think if you agree with me that you still don't imply terms that the contracting parties clearly could have written into the provision, which is what they're trying to do. They're trying to say...
Does that just mean it's not ambiguous, though?
I think that it's just an exalted form of a particular rule that with sophisticated parties, even if you find ambiguity, you ought not be reading language into the contract that they could have put that's not there.
This ambiguity doesn't count? Is that what you're saying?
I don't think it's ambiguous, but
No, but I mean, is that what you're saying? The court says in these cases, this kind of ambiguity, even if it's ambiguous, it doesn't count. It's not material. Who cares?
Well, they don't go into that big of an explication of it. I recognize that if you find ambiguity, the far more likely scenario in most cases is that you go to a jury trial on the meaning. What I'm saying is, first, you shouldn't find an ambiguity here based on the argument Samsung is making. And second, if you look at any of their pieces of extrinsic evidence, there's no way a reasonable juror could look at that and go, I hereby import into section 6.2 a joint development limitation. There's just nothing there that would support that.
Any other questions by my colleague? Thank you for your argument, counsel. Mr. Yoder, you have a few minutes.
Thank you so much. 3 points I'll make. First, on 6.2, the issue is whether this provision it can be interpreted to limit the supply obligation to the joint development project and the product that would be developed. At a minimum, the agreement is reasonably susceptible. Judge Amman mentioned components. Components of what? What I would point the court to is the definition of the NVDIMP product in the JDLA, which makes very clear that the components are the memory chips, the NAND and the DRAM, and the controller. They're specifically...
Actually, the definition talks about memory like DRAM with a higher density of slower memory, or like NAND. It doesn't talk about, I think, exactly the way you've read it. And it also talks about another device such as the PRAM, which is not part of the supply obligation at all in 6.2.
Neither side would be supplying that as part of it. But these are clearly components. Components for what? The title is Joint Development Project. Again, they're saying you need to insert some limiting term. Well, the extrinsic evidence
But you
shows...
would agree with me that Netlist had a purpose for purchasing. In fact, you talked about how they purchased these components prior to the JDP, correct? So there isn't, you're not saying here today that the only reason that Netlist would purchase these component parts was because there was a JDP, right?
Correct. But the purchase of the components for resale, the purchase of the NAND and the DRAM to sell to third parties was outside of the joint development agreement. The SEC filings that Netlist made, where they say we have no long-term supply agreement, shows that. The fact that Netlist kept coming back to Samsung saying, give us an unlimited supply agreement, shows that. All of that shows that. The thing I would say on materiality real quickly is that the evidence was before the court. And if the evidence showed that the parties did not intend an unlimited supply obligation to be the primary consideration for these licenses, then even more so, it wasn't material. It wasn't a material breach. And all of that evidence was before the district judge. If you look at his ruling that he made in connection with the summary judgment decision, he said that, and bear with me, I know I'm a little bit over, this is the last point that I'll make. Netlist, in its reply, acknowledges that there's a fact issue on materiality. Netlist said that if Samsung was suggesting that there's a fact issue on materiality, there isn't. Look at this extrinsic evidence. The district court looked at extrinsic evidence on materiality. It relied on Mr. Hong's self-serving declaration. It ignored all the other evidence in the record about the 3-year delay in claiming a breach, about the statements that were made to the SEC, all of which we submit show that this wasn't material. Okay. Final point is that if there is to be a remand, we would ask the court to consider allowing Samsung to raise its affirmative defenses, that those weren't required to be raised as part of a summary judgment. And I would just point the court to...
Isn't that too little too late? I mean, you should have raised those in connection with summary judgment. You didn't do it.
May I answer that question?
Yes.
Okay, and I'll be brief. No, if you look at, the best thing to look at, Your Honor, is the district court's order on summary judgment. There was a lot of confusion about what the motion was. The notice of motion said the merits of our claims. I don't know what that is. Their points and authorities talk about the 4 elements in New York, one of which is damages. The others are, a contract, Netlist performance, Samsung's breach. But what the district court did when he said, here's my ruling on summary judgment, it was as to 3 elements. It wasn't as to liability as a whole. It was existence of contract, performance of contract, and Samsung's breach of the supply provision. That's 1 ER 41. In response to a summary judgment motion that identifies 3 elements and says we want summary judgment on those, I don't believe that Rule 56 requires a defendant to put in affirmative defenses.
Okay.
Thank you so much.
Any other questions by my colleague? Thanks to counsel.
Thank you.
This is an interesting case. We appreciate the preparation and your arguments. The case just argued is submitted, and I'm pleased to say that the court is adjourned for the week.